Two federal high courts on Tuesday issued conflicting orders on the political crisis in Rivers State. The first one nullified the state's 2024 appropriation bill of 800.3 billion naira that had been passed by a faction of the Rivers State House of Assembly, led by former Speaker Edison Ehi, and signed into law by Governor Sim Fubara. It ordered the governor to represent the budget to the new Speaker Martin Amewule-led House. A few hours later, another court ordered all the parties in the matter to maintain status quo, pending the determination of an ex parte motion filed by 6 elders of the state to stop Governor Fubara from representing the 2024 budget. Well, Malachy Ugwummadu is a former national president of the Committee for the Defense of Human Rights and a human rights lawyer. He joins us now to look at the significance of those two conflicting judgments on the 2024 Rivers State budget. Many thanks for joining us on Newsday.
Thank you. I'm delighted to be back.
Well, so how do we interpret this conflicting court rulings on the passage of the Rivers State 2024 budget?
I think the better approach is to characterize it. To interpret it will lead us to more confusion. And the character I seek to give is that of a mixed feeling. One on the part of the lawyer speaking now, who belongs to this very industry, to say that there have been repeated admonition dished out by heads of the judiciary, no less the Federal High Court, warning against what has now generally been known as conflicting judgments. Make no mistake about it, most of these conflicting judgments have arisen from political matters. And you keep wondering, why must it be so? It is not only, in short, political matters, however sensational and public in nature, take very minute aspect of the entire volume of litigations that go to our judiciary. Yet, it has now become very confounding, very confusing, and very conflicting. At the end of the day, what we have in our hands is the heightened confusion in the public. And I have repeatedly made what I consider to be a valid point. Pardon my immodest position here. It is that the notion of justice does not disappear at the point where you win or lose a case. It evaporates when the public gets confused about what is going on in the judiciary. And I think that is, unfortunately, where we all find ourselves. So, on the one hand, a judge of coordinate jurisdiction, the same jurisdiction, says status quo should be maintained. The other one says take no further steps. If you want to put it as bad as it is that the litigants, so to speak, thought they would get a leeway without necessarily taking arms or the laws into their hands. But they have now learnt better that even the judiciary they've run to has not helped them. I say this because of the confusion that now pervades the environment, the political environment. It is not so different from what you have in Jos, Plateau, and so on and so forth. For me, what needs to be done is that the judiciary itself, particularly that of Rivers State, should find a way, and I'm speaking to the Chief Judge, the Chief Judge of the Federal High Court, will find a way of, speaking to what has happened and the way forward. Anything short of that, in my view, will lead the people to more confusion. And this is a very emotive issue. It depends on where you stand, how you want to interpret it, or in my words, characterize it, and you run with it. There are those who are firmly entrenched, taking the first ruling. There are others who feel that, oh no, it is the one that seeks to stay further action pending the determination of the suit instituted by the elders, Council of Elders. So it's a catch-22 situation.
It's a real stalemate, a real quagmire. But would it be fair to say now that the National Judicial Council should be stepping in and sanctioning or warning quite severely some of these justices that have been involved in these conflicting judgments?
The duty of the National Judicial Council has never been a palatable one. I don't envy those who are there. And for as long as they run away from difficult decisions and actions, for that long they continue to deplete the integrity of the judiciary. This is one of such occasions when they will have to rise to the occasion. I say this because repeatedly there have been admonitions, clear directives, in short, very stern warning, particularly regarding injunctions, arising from political cases. Judges have been warned to be very circumspect in dealing with that. You could argue that this is not so much about orders for injunction. However, it is a political case. Now, if you watch the time frame within which these two cases came before the same court, and when you say the same court, we are referencing the Federal High Court, the Port Harcourt Judicial Division, you would find that there was the need to have a comprehensive picture of how these cases were coming, because it starts from that. If a case involving the same parties or likely to affect the same parties have come in one court, and you have a repetition of a similar case in yet another court, there is a need that you have to have a global picture, a comprehensive picture of those cases. In short, in most times, if possible, and if the conditions exist, you seek to consolidate them. That way you avoid different rulings that could be conflicting as we now have them. So in my view, the National Judicial Council should appreciate that this has become a very sad commentary. And it doesn't taste well or smell well at all. And then questions must be asked. What has become of the admonitions, of the directives? To what extent can this thing be so loose, so fluid, that even the common man on the street gets more confused, worse, and even more confused when they approach the court? You needed to be cleared regarding what was otherwise confusing to you as you approach the court. But this time, the public become more confused. There is no certainty of the law any longer. And by the time every Dick and Harry is interpreting the law, depending on where he or she is standing, we're gradually looking at the last bus stop before anarchy. And it's as bad as that.
Now, in reaching his decision, Justice James Omotosho said that Governor Fubara had, by withdrawing all the processes he filed in the suit, admitted all the allegations against him and was thus deemed liable. Now, how would you assess the governor's chances of success if he decides to appeal this ruling?
Well, two constraints that I have. The one is that these matters are still sub judice. The other is that they are largely political than legal. Do not forget that it is with respect to these cases too that they were all summoned, railroaded to the presidency, where directives were dished out. And as we now see it, the governor of Fubara has clearly demonstrated to be of a mean character, one who continuously wants to avoid any controversy. And if it even affects, if it will expose him to any form of confrontation, he would rather withdraw into his shell, even if that would affect the people he's leading. Because that's the issue. It's not about Fubara and how he detests controversy. It is to what extent would these supervening directives to an elected chief executive impact on the electorate. I would not be proud to have that kind of person as a governor. That is one. The second point is that the entire notion of federalism is thrown overboard with what we have seen play out in. What is President Bola Tinubu's power to be able to dictate from Abuja what must happen with respect to judicial contestations in Rivers State? I recognize that there are political angles to this whole thing, but to be able to do it with such magisterial power and with finality in such a way that even the citizens of Rivers State will have no say, for me, it created much more challenges than many people are willing to accept. So to unlock all of that is to begin to think of a population of a fresh consciousness amongst the populace, among the electorate, among the citizens of Rivers State, that will extricate them from this bandwagon approach, led by a very pliant governor, who, in my view, is not very critical about what is going on. From one stage to the other, he boxes himself into a very tight corner. And it, as a close watcher of political development in this country, one can now understand why it was very easy for Minister Wike to identify him to be his successor. And if there were no resistance, one will imagine what would have happened by now. I think I will leave it at that, just so that I don't complicate my narrative.
Please don't do that. Well, is it fair to say now that this Wike faction versus Fubara faction war is still low level, but is still continuing? And is it also fair to say that Governor Fubara might not have the best counsel on his side, the best advisors, the best strategists?
I wish in your suppositions that the people's factor too was one of the variables we are considering, from Wike to Fubara. The main important people to think about is the people's angle to all of this. Sure. Unfortunately, and you were right, you could see that we are still politicking. We ought to be in the business of governance, but the raw agitation for power, raw power, has not ceased. The dust in the belfry has not settled. We are yet to get to the point where people can see clearly. In short, the people of Rivers State look, but they see less. They hear, but they don't understand what is going on. So, what I think is important is already happening, although caught in the web of judicial manipulations now. Those council of elders who approached the court, in my view, had a very solid course of action. It is possible that you will have a good course of action, but run foul of some technicalities in advancing or actualizing or giving effect to those courses of action. But as lawyers, there's a popular phrase we have in Latin, ubi jus, ubi remedium. Once there is an injustice, there is always a remedy. if that is true, then his team of lawyers, and I hope he really has an informed team of lawyers, should be able to go back to the drawing board. In my own practice, what I do most is usually to critically understand what the issues are, redefine the music, not the one you brought to play. I will not dance to your own music. We'll do it in a way that you'll be on the defense, I'll be on the offensive. To the extent that I'll be looking out for what it is that will enable me get to the end game, rather than the music you have set for me to dance to. So I think that there's a need for the Rivers State people to find their feet now, rise to the occasion, reorganize themselves, build fresh consciousness, understand what issues are, and redirect this whole drama in a way that empowers them beyond these gladiators that are running roughshod on them.
Now, in the meantime, a state high court, sitting in Port Harcourt, struck out a suit challenging the legality of the deal signed by Governor Fubara and his predecessor, Nyesom Wike, which of course we know was mediated, by President Bola Tinubu. The judge said the court did not have the jurisdiction to entertain the suit based on the ruling by Justice James Omotosho, that the governor should go and represent the budget. So I'm wondering, what other options are available to the applicants who filed this suit?
So there are reasons advanced for that. It could be as simple as they did not have the local standing. It could be anything. It could be that the causes of action that has brought them to that particular court does not vest the appropriate jurisdiction needed to invoke the powers of the court. It could be anything. For me, since this is still ongoing, and since the people of Rivers State and the government of Rivers State have not found the appropriate leeway out of it, it is to go back to the drawing board. There must be reasons why that was discountenanced and struck out. And I'm saying that if they felt strongly about it in the first place, they should be able to find alternative means of advancing even the same case more appropriately. Again, you could watch time. You could ensure that time mediates through all of this. If it is that there's an earlier court order, that needed to be obeyed before you're able to take this step. It's a question of time. Once that time lapses, and you think that the course of action is still there, and it has not lapsed, and that you still have interest, and you believe that it is through that means that you can advance your case, the lawyers are up to their game. They will find a way of reintroducing the matter without necessarily allowing the state to slip into anarchy. Because that is gradually what is happening. Don't forget, this is the same state in which, in one fell swoop, an entire legislative house came down. This is a state in which, every election cycle, it is identified as one of the flashpoints in the country. Heads are decapitated until very recently. So it is in the best interest of the people of Rivers State. And mark my words, I keep emphasizing the people of Rivers State because they are now the victim of these intrigues. In the political calculation of Rivers State, the people have become inconsequential. And it should not be so. They ought to take the primus position, and so on and so forth.
Well, this is all something we're going to continue to watch. It's a case of legal gymnastics, so to speak. Mr. Malachy, it's always great to have you on our program. Thank you so much for joining us here on Newsday.
Thank you for the opportunity.